Hello, ladies. How are you doing?
Excellent, thank you.
So I'm very happy to see you. Some of you I've already interviewed before, Sarah and Anita, but it's always nice to interview again. You're always welcome to come back on this show as many times as you want to. And Cheryl, it's very nice to meet you. And thank you for taking the time. We know that you're on vacation right now, and still you took the time to be with us because we are going to be talking about an important subject today and very interesting one, and it is about interveners. There is a current trend that we've been noticing at the Supreme Court level when it comes to interveners, and we will get into that. But before that, we're going to start with the basics and just maybe start by explaining what are interveners, what is the role of an intervener, why are interveners important, and a little bit about the rules that apply to them and how different they are as opposed to the rules that apply to the regular parties. So I don't know who wants to start. We'll just maybe Anita wants to start with the basics and
Sure.
then we'll take it from there.
Yeah, happy to start. Thank you, Maya, for having me back. As you know, I like to come by weekly, so happy to visit again. Cheryl and Sarah will correct me if I'm wrong, but I think it's helpful to just start with broad strokes. And over my career, I've been counsel to various public interest organizations in essentially every level of court and tribunal where intervention is permitted pursuant to the rules. And I think the principles are the same. So, in effect, there are two main things that a potential intervener has to demonstrate in order to be granted leave to intervene in any forum. The first is to demonstrate that the organization or the group has a direct and substantial interest in the matter. So, in the case of a Supreme Court of Canada appeal, you have to have a direct and substantial interest in the appeal itself. And second, you have to have a unique expertise or perspective to bring to the case. So you have to have either some expertise or experience that is different from the parties, or perspective or an analysis that's different from the parties. And weirdly, there's an expectation that you promise the court up front that what you're going to contribute is going to be new and different from what the parties will be submitting, but also different from what the other interveners in the case will be submitting to the court. And I find that part a little bit difficult to satisfy because, of course, at that early stage, you don't necessarily know, you're more likely not to know who the other interveners may be, and certainly what their positions or submissions may be. So I think those are the broad stroke bases for a potential intervention at the Supreme Court of Canada.
Just before we get into the rules that apply to interveners, I just wanted to clarify something. Does an intervener have to be a group or an association, or could it be an individual?
I can jump in for that one, it's Cheryl. And it can be individuals. It does sometimes happen. And interveners can have slightly different roles. For the most part, especially at the Supreme Court of Canada, where it is just about the law, interveners can't really comment on the evidence or raise evidence, and that would be relevant to the hearing. But at the lower court levels, sometimes interveners come in and are actually permitted to submit evidence. It's rare, but it does happen. So you can have interveners that have a quasi-party status because they've been able to prove that they have an actual direct sort of stake in the actual litigation that's going on. But it is somewhat rare. I've even seen it in one case, the case called Cacoponus, where an intervener was permitted to file fresh evidence at the Ontario Court of Appeal. Again, highly unusual, but something that can happen.
And Sarah, are the rules the same for interveners when it comes to the timelines as to what they can do? Like maybe you can tell us a bit more about that.
Yeah, so if we're talking, and I'll stick to the Supreme Court level because that is where our conversation is going to head. An intervener can get involved in two stages of the proceeding. The first is if the case is one that's not going to the court as of right, and if leave is required to convince the court to hear it, then it's possible for there to be an intervention at the leave application stage. So if the issue is one that the potential intervener wants to support in suggesting that the court ought to hear it, it needs to be resolved. It's causing, particular impacts that they're able to speak to, whatever the basis of that is. It's certainly not frequent, but it is permitted by the rules. In the substantive hearing context, an intervener's deadlines are triggered by the filing of the appellant's factum, because at that point, the issues before the court and the way that they're being presented are crystallized enough for a potential intervener to be able to describe what they would like to contribute, what they're able to contribute, what the court might be missing. So they are, you're making the application to be able to file a factum, to be able to make oral submissions. The length of the factum is shorter. The length of oral submissions is significantly shorter. And then, of course, the intervener's not in a situation of being required to file, and is prohibited in most cases from filing, an appeal record, evidence, the sort of stuff that the parties are required to contribute. Their contribution would be in the form of a much shorter factum, and their oral argument if they're permitted to make one.
All right. And is there a limit on the number of interveners that we can have in a case?
Apparently.
So Anita.
As it turns out, there might be. I mean, when you ask the question about limits on factums and timelines, unless I'm missing something, that's not sort of statutorily or enshrined in regulation or anything. I think that is just something that the court determines as people make their application. I could be wrong, but I think certainly as a matter of practice, that has really fluctuated over the years. So I've been doing this for decades, and I think Cheryl will agree, and maybe she can fill in some missing pieces as well. But when I first started appearing in that court, I think we did get up to 20 minutes as interveners in time to make oral argument. We're now down to 5, and it's uncommon or even unheard of now to get more than 5 minutes of oral argument in that court. And some people sort of minimize the import of that and say, well, what's the point? But I think actually that from an advocacy perspective, that 5 minutes is a real challenge. It's the whole sort of, sorry about the long letter. I didn't have the time to write a short one. I think it's much more difficult to craft an effective 5-minute oral submission than if you have hours or unlimited time to do so. So the question about numbers of interventions and the ability to access justice really at the Supreme Court of Canada. And I think what we're really talking about today is access to justice at the Supreme Court of Canada level. You're right, we started the session by saying there is perhaps a notable trend at the minute to sort of curb the number of interveners who are granted leave to intervene. And I don't know, and I'm not sure that anyone knows whether that's actually a trend of the court or a particular approach or preference by some of the justices of the court. It's important to note that the decision whether or not to grant a proposed intervener an ability to intervene is the decision of a single judge of the court who makes that determination, reviewing all the applications. So we have noticed. What's interesting is over the last number of years, the numbers of interveners in any particular matter, including the most contentious appeals, really skyrocketed. So I think everyone here was involved in, for example, AGBC, which was the high watermark for me of 22 interveners. But I understand that those numbers were even higher. I think Sarah speaks of 36 interveners in some of the most contested criminal law appeals. So that's really a huge number of interveners. And you can see why at some point the court might have, started to shake their head a little bit about how much time are they setting aside full days of hearing to hear 36 interveners, and does that take the court away from the core issues that directly affect the parties, because that's not something that's intended. So I don't know, but the short answer is there appears to be some change away from just sort of letting everybody who has an arguable application in. So I'll stop there for a second because somebody wants me at the door.
And I'll just add that the real increase in proliferation of interventions in the court letting in lots started with the TWU case. So the Trinity Western University challenge that to the Law Society's refusal to accredit their law schools. So I mean, it's a notorious case for that reason. What happened was the single judge who reviewed the intervention applications did only let in, I think, approximately maybe half or less of those that applied. And when one looked through the list, none of the interveners actually represented the groups that were most affected, particularly with the LGBTQIS two groups. So there was a firestorm on Twitter, actually, and it was the first time you really saw social media having this huge influence on the court. And a few days later, Justice McLaughlin stepped in, because it was Justice Wagner that had made the decision around the interventions. And she stepped in and granted intervention status to everyone who was in, who had applied. So that was at that point the high watermark, and that was 26 interveners. And then we since then have seen cases with that many or more. So the one that the Asper Center was involved in as an intervener was the Quebec reference into the constitutionality of Bill C-96, which was the legislation for First Nations, Métis and Inuit children and families. And there were over 34 interveners in that case. And so we've been seeing a few like that. And I think what we're seeing, I agree with Anita, now they seem to be dialing that back. And quite frankly, in the Quebec reference case, there were 34 interveners, and I believe maybe only at most 3 or 4 of those intervener arguments made their way into the judgment. The rest of the arguments were about an issue that the court skirted and didn't want to address. So, I mean, it was an important issue. It was hard to anticipate that the court would do that, but that's what happened in that case. So there is a real issue when you have that many interveners, whether they're going to be talking about issues that are of relevance to what the court is going to consider.
Well, and I'm going to ask both of you, and Anita can join whenever she's back. But can interveners make a party win their argument? Or is it at the end of the day still going to be the main arguments that are made by the parties? Like, can they make someone win a case?
So I think one of the complicated things about interventions at the Supreme Court level is that the answer to that question is not clear in the way that it might be at the trial level, because at that stage the facts are clear, the issues are clear, the implications and the knotty philosophical questions that the issues raise are relatively clear, and have been hashed out at least 2 levels and by the parties in their facta. And so what the court is deciding is much more in the realm of what the rule should be, and in some cases, what kind of rule we want, what's the societal interest in this, what kind of rule do we want? And so the parties are advocating for, and I've been in that role as well, a particular interpretation, a particular outcome, a particular gloss on the law that has the result of the client winning. But the rule that is to be applied, and the shape and scope and nuances of it are often the thing that is up in the air. And so when interveners are useful, from a party perspective, I guess, or when they have the potential to impact the outcome of a case, it's not so much that they're causing the party to win or not, but that the way that they have, the perspective they've offered the court, the information, the angle on the difficult decisions that the court has to make, has given the court some comfort or clarity on which way it is that they want to go. And a good intervener can make a significant difference in helping the court resolve that question. And it's part of why you both see in, we're sort of concerned that there may be a trend developing. There is certainly a debate going on, and it's, we got a new practice direction a few years ago. It is more alive than it's been in the medium past. But you also see a sort of pendulum swing from, I think, going back to Delgamec or the same-sex marriage references, right, where you have 28, 30 plus interveners. And a lot of that goes to the complexity and the extent to which it is a pure judgment and values call, as opposed to a legal issue to be resolved. And the more help there is in thinking it through, potentially the more useful, but also the more there's a risk that the court is going to feel that the interventions have lost sight of what they think the core of their work in that case is going to be.
Right. I mean, because what the interveners are adding to the case is that they're showing that the case has an impact not just on the parties, but on other groups as well outside of the case itself. And also, I mean, the Supreme Court at the end of the day is a national court. It's not just dealing with issues for a specific jurisdiction, for a province. It's really for the whole country. So it is more important at that level to take into account the impact of a decision, not just on the parties, but on the country and different groups in the country outside of the parties. Yes, go ahead, Anita.
Well, as with everything else, I see parallels and similarities in terms of intervention at the Supreme Court of Canada level. And for example, coroner's inquests, where I participate on behalf of public interest parties all the time, where the public interest sort of preventative aspect of an inquest is looking down the road to make recommendations to improve things in future for everyone and to prevent, certain kinds of deaths. So you need the public interest intervention to inform going forward on the impact of those still living and everyone of what happens and how things are done policy-wise, law-wise, and so on. At the same time, you're holding a coroner's inquest because somebody's dead, and you're not supposed to take the process away from the central focus of examining that individual's death, because but for that death, you wouldn't be there. This is not, it's not a commission of inquiry. It's not a public inquiry. And in the same way, the Supreme Court of Canada, references may be a bit different, but when you're talking about party-driven litigation, the Supreme Court of Canada is ultimately determining a dispute among two parties, or the state and the defendant. And all of that intervention shouldn't take the determination of those rights so far afield that you're having a very academic, very theoretical sort of, in the clouds discussion with no practical application. So in fact, the best intervention, my view, is assisting the court with that practical application to provide the context of you're determining something that will impact the lives of real people in certain ways that the parties themselves are not in a position to educate the court about. They've got their own fish to fry, their own unique facts. They may not be aware, and they certainly don't have the space or the time. It's not their job to provide broad context on how certain communities will be impacted. So that's one way. Another way is individual lawyers who are defending a particular client in criminal context at trial, for example, may not have sort of, the incredible historical or institutional expertise on charter litigation, very difficult charter issues, which is where, of course, Cheryl and the Asper Center would come in, for example, to contribute a particular kind of legal expertise that simply may not be known to the parties at hand. So, Cheryl, I think it's a good time maybe for you to talk about what you do at the Asper Center in terms of interventions.
Sure. I mean, I'll start with something that I did before I went to the Asper Center, which was when I was counsel at Justice for Children and Youth. We found that in many cases, knowledge, even by counsel, defense counsel, on how the Youth Criminal Justice Act, for example, worked, was not very sophisticated. And so there were a number of interventions that we did that really were helping the court, and there were also cases that the court, especially once it gets to the Supreme Court of Canada, doesn't deal with those kinds of cases very often. They don't tend to reach that level of court. So they needed somebody there to say, this is how our youth criminal justice system really works. And there were two cases. One was a case that came out of Newfoundland called FN, back when it was the Young Offenders Act, so previous legislation around privacy of records. And we had 20 minutes to make the argument there, but really it was clear that my role was really educating the court about how everything worked. And subsequently the case of DB, which was about the presumption of reduced moral blameworthiness for young people. We had a huge role, but at the Supreme Court of Canada, we were not given very much time because, in fact, what happened at the Court of Appeal, we made the charter argument, not defense counsel. The defense counsel just ceded all their time to us and let us do that piece. So we had laid the groundwork. So once we got to the Supreme Court of Canada, we were given the usual intervener time. I think I might have had 10 minutes at that point because it was being reduced to that. But at the Asper Center, we tend to be a bit less practical, I guess, in some ways, because it's more of an academic approach. And so we've been very successful in some cases that have helped the court. I'm thinking like the Bedford decision around the whole issue of stare decisis in charter litigation. Well, it sounds very academic and boring, and nobody else wants to argue that argument. And we said, hey, it's going to be fun for us. Let us do it. And it made a huge difference because what the practical aspect of that case was that it reaffirmed what the trial judge had done. And so it allowed the trial judge to look at the issues afresh, even though, the case had been, or the legislation in that case, the prostitution sections of the criminal code had been determined to be constitutional 20 years before. And and Justice Himmel was able to look at it again and say, well, lot has changed since then. And so we may just reaffirm that argument at the Supreme Court of Canada. The most recent one where we've had a huge influence, and we can talk about also joint interventions and how interveners should be working together. We jointly intervened with Leaf and West Coast Leaf on the Section 15 argument in the case that was the challenge to the Safe Third Country Agreement in the immigration context. And we were the only ones there arguing Section 15 of the Charter and saying that what the first level court, the federal court, trial court had done was wrong, and by failing to actually even consider the Section 15 arguments. And the government was trying to argue that the parties had given up and had ceded that point because they hadn't devoted a huge amount of time in their factum to it. They didn't cede the argument, they just didn't have the scope to be able to make the arguments and relied heavily on what we argued. And we argued that by failing to address Section 15, what the courts below had done was created this hierarchy in which Section 15 equality claims were somehow less important. And the court that resonated with the court. So it got sent back to be argued, and it's going back to trial on that issue because of our arguments. So we can, even though it's kind of sounds like an academic argument, it can have real practical effects. And so it's one of the interesting things I like to do on behalf of the Asper Center is put forward those arguments.
And I think we're all grateful to you, Cheryl, and to the Asper Center for, you know, I'm glad that you said it so that I didn't have to, this business of doing things that nobody else wants to do that have to be done. I think in Sullivan, Chan, and Brown, we were lucky enough to intervene and sort of give a, very practical perspective of people who use drugs and the ways in which they use them. But ultimately, if you've ever read that judgment, the decision in Sullivan actually is available in Brown, whereas what happened, the actual judgment in Sullivan, despite being counsel to one of the interveners, have not been able to finish, but I understand is very, very, very important about lateral precedent and so on. And those are the kinds of things where, very smart, very expert intervener can really help the court struggle with these hugely complex, very legal issues that the parties can't be expected to dig into, and other interveners really are not going to have the expertise to provide. One of the things I think we want to talk about is where the court is cutting interveners now, though. So I think we all understand that there may be legitimate frustration within the court with the ballooning numbers of interventions. I have noted different other kinds of concerns, but it's not just the numbers of interveners. I think there are probably other things that may be irritating to the court in terms of intervention. There are certainly habitual interveners. So there's certainly organizations who seek leave to intervene pretty much anytime anything touches upon whatever their mission statement may impact. And I don't think it's necessary to come to every party, right? So there are certain things that people could sit out where there are others willing to assist, or where what they want to do is ultimately a bit tortured, right? So we've also seen sort of attempts to intervene to make a fancy sort of too clever by half argument, something somebody wants to test out, that is really far divorced from something that needs to be determined in that moment, in that factual context. And I'm not a justice of the Supreme Court of Canada, but if I were, I would find that very irritating, because for sure what the court is not there for is to entertain, lawyers who want to have some fun and float some things by in these, very esoteric fields, far afield from what they need to determine. So I think there have been a lot of irritants and a lot of conversations that maybe ultimately haven't been helpful. But where we're at now, what my own concern is it's not sort of just an attempt to reduce the numbers of interventions that we're seeing. I think the question now that we have to ask and wonder about whether it's a general direction, a general trend, or whether it's a, not necessarily a one-off, but a two-off or five-off on a particular case. But what is the nature of the proposed intervention that is currently receiving disapproval? What message is it that the court is sending to interveners? And I think this is, a conversation. We're talking about a conversation with the court. We're not actually having a conversation with the court, but perhaps we should. And in a way we are, because we're receiving messages. We receive those messages through leave applications that are denied and leave applications that are granted. And I think we're all trying to make some sense of it. So my own concern, and perhaps I'll just by way of background indicate that throughout my career, I have acted as counsel to every kind of organization you can imagine, from the smallest, pro bono, completely not profit, unfunded, a collection of some people who've shared a particular history of using substances or having mental health issues, to the largest organizations in the country. Very big organizations on very important issues. So I've represented all kinds of people, including at the Supreme Court of Canada. But what worries me now is we are not seeing these really big organizations who are habitual interveners being denied leave, but we are seeing particularly those little community groups whose particular expertise that they have become used to contributing is a lived experience context for the impact of the decision. And increasingly, it's those groups who are being denied leave to intervene. That would trouble me And it, in fact, is troubling to me because I think it then becomes an access to justice question in the Supreme Court of Canada. And I just want to flag that when I first became involved with representing mental health advocacy groups who are comprised of people with lived experience, it was because of the kind of thing Cheryl mentioned about the defense bar at one point not being particularly educated about the Youth Criminal Justice Act. So, for example, the criminal defense bar as a bar has not historically been very attuned to the difficulties of people with mental health issues within the criminal justice system. So a lot of criminal defense lawyers as a bar have approached forensic psychiatry or psychiatric detention as a panacea, as a benefit, a therapeutic benefit for people. And the clients actually don't like it there. So what the original impetus for the intervention by people with serious mental health issues was to contribute their own perspective, to say, look, this kind of detention is bad for us and it should also be avoided. So that's when they first started to raise their voice so that they would be speaking for themselves, nothing about us without us. And 25 plus some years ago, the Supreme Court of Canada opened its doors to people with lived experience and mental health issues, and they've been very welcoming since that time. So when we saw things like, Justice Michelle O'Bonsawin being appointed to the Supreme Court, and when the court and everybody started talking about it's important to have representation and it's important to have people with experience in mental health issues, we were so encouraged by that. We thought, the court remains interested in making sure that people with mental health issues that they're understood, they're heard, and they can participate. And then all of a sudden, that kind of lived experience is finding itself shut out at the minute in this very moment in time. And that is extremely alarming for us. And I'll explain specifically why. So what happens is the big organizations and the little organizations who are seeking leave over these last many years, we've sort of, maybe we've become spoiled, maybe we've all been entitled, but we've just assumed we're going to get leave. By and large, if we have a strong record of intervention in that court, we would largely expect to be granted intervenor status. So we all have had this very friendly, collaborative sort of relationship where we know if someone's coming, we all sit down together, we look at the issues, we divvy up the pie to make sure that we're not duplicating arguments because the court doesn't want us to duplicate. So to put ourselves in the best possible place to assist the court, we work collaboratively before anything happens and everybody agrees on what they're going to contribute. Then we go away and we contribute because we had not been anticipating being denied leave. But people put in their leave application materials that I'm proposing to target only this one argument because it's my expectation that others will speak to these other issues, including the impact the court's decision will have on the community. And then they also say, but if they don't, for some reason, we will also contribute that. So unfortunately for my clients, where we're at now is if they don't get leave, you've got these big juggernaut organizations who have protected themselves in a way by saying, if they don't get in or no one else does it, we'll speak for them. And then, of course, my clients are saying, oh, that's what we didn't want 25 years ago. We started coming to you because we don't want them speaking for us. And now we don't even know what they're going to say about us. So actually, in a weird way, it's a crisis moment because in a weird way, if that's where we're headed, if the lived experience contribution to provide context is going to be discounted and excluded, then we're going to have a problem where, in effect, we may be setting the intervention clock back some 25 years. So we could be facing a crisis moment, or we could be seeing the impact of a number of judges who've made their own views of the limits of intervention very clear through the jurisprudence. I think we're discussing McGregor is a case that sets out a number of different perspectives on intervention by different justices of the court. But that's also not great because what that means is you can tell by which judge is considering the leave applications how those decisions may be made. And that's not what we want from our Supreme Court, and that I don't think is how it's going to roll. Anyway, that is some lots of food for thought, I think, and fodder. And I know I've said a lot there, Maya. You look like I just covered like 18 next steps in the discussion, but I'm sure Sarah and Cheryl have a lot to say about all this stuff. I think it's a moment in time. It's a moment in time that we need to take seriously.
I think it's both. I mean, I think it's both. I mean, I have, I think it's both. I mean, 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 I think in some ways we can't, I mean, we can't know because we don't know how it's going to progress. But also we have, in theory, some faith in the common law as a system where when views are articulated and debated in the open, we come to resolutions, information gets offered. And so in theory, we have this debate going on, discussion going on that can, you know, be advanced in particular directions with the input of the bar, the input of the affected parties in a sort of the broader legal context, not in particular cases. But I also think part of what is missing, or what I have not, and I, you know, was poking around today trying to get a sense of, you know, is this cyclical? Is this a pendulum type issue, or is this new? Is, you know, are these views that recur and recur? Is what's the, how worried should be essentially, or how much is changing? And one thing that seems to be missing from the conversation every time it crops up over the years is interveners are helpful for the same reasons that a trial is an extremely useful way to resolve issues between two parties. It's hyper-focused, the evidence is directly connected. It's a bad way to resolve national level complex legal issues that the parties are not arguing about and that don't concern the trial judge and that don't get hashed out below and remain not their problem. And we have interveners in part because we've recognized, and the court has recognized, there's a bunch of crucial information for the job that they now have at that level of hearing that they need to make that decision fairly reasonably, given the scope of the impact that's going to happen. So we've you know, theoretically implicitly said that's true. That's why interveners are helpful. We've created this possibility, but we haven't had a particularly explicit conversation about what's missing. So it feels in part like we have this anxiety about new information, the record, unfairness to the party, up against information that we've accepted is missing, context that they need. And a lot of the time, because that conversation has not been explicit or detailed, it's happening in proxy ways, right? It's happening by a legal organization with expertise on the impact of people living with mental health issues in the justice system, talking about that within the scope of the law, because that doesn't feel like evidence. That feels like expert input. And so we can deal with the anxiety about the record, fairness. And so I think that part of the problem that needs to get addressed, or hopefully would get addressed, is that missing the conversation that we're not having, and that the court is not having directly. We know what we don't want, right? We don't want affidavits, testimony, witnesses, new facts, but we aren't that clear. And part of the problem is we don't know what we do want. And so that really impacts whether we're good at getting it from the best source, people with lived experience, as opposed to putting it through some sort of professionalized filter that alleviates that anxiety about unfairness evidence, you know, an unbound read kind of intervention and cracking that box open. And it does feel important that like that, to me, that feels like the thing that's happening a lot of the time when this conversation pops up. And until we address it sort of head on, we're going to keep having this resolution that feels like a resolution, but in fact raises its own access to justice and fairness issues.
Part of the problem is that the court is not, it's divided itself on these issues. So if you look at a case like Sharma, where the majority, which was a bare majority, is critical of what interveners did at the court below, and I'll out myself there, we were part of that, in the interveners that were criticized. Again, another joint intervention we did with Leaf. But the dissent, which was a 4-judge dissent, so it was, you know, on a knife edge, thought that it was not a problem what we had done in the Court of Appeal. And really what we had done was refer to Royal Commission reports and things that court had accepted as and taken judicial notice of for years, but there was this little you know, thing about it from the majority. And so there's certainly the court has been inconsistent about what they want from interveners. They've been critical of interveners. McGregor is an example. Anita, you mentioned that case. They let us in to argue about HAPE, which is a decision about the extraterritorial jurisdiction of the charter, which everybody says is a nightmare of a case and really badly reasoned and needs clarification. They let us in knowing that and there were a number of interveners, wasn't just the Asper Center, saying we wanted to address that issue. The parties, you know, also said they were addressing it not quite the way we were, but it still was an issue that was squarely. And again, the dissent said, you let them in. Like, of course they were going to argue this. And the majority said, what were they doing raising a new issue? This is ridiculous. And so we have this inconsistency from the court, and it's really hard to gauge what it is that we should do. I also think that interveners have to own it too. So, and the intervener bar, if there is such a thing. These intervener pylons on a case, unlike, I mean, some of the cases involving Indigenous rights and treaty rights, there's a lot of First Nations that want to have a say because it's going to impact each of them individually in different ways. And I understand the expansion of the list of interveners in many of those cases, like Dalgamuk and many of the others. But the criminal cases, the other kinds of charter cases, I don't know why we need 26 interveners. And we do end up with this problem of arguing these very narrow pieces of argument just to sound relevant and sound like we're not stepping on someone's toes.
Yeah.
And I've been in the situation, and then most recently a case where we got in, and I mean, I was dismayed to hear that we got in and not some other groups, because it was the other groups that asked us to come in and said, please, please, please come in. I said, I don't know. It's not really our area, but no, it'd be really helpful if you made. And so we really consulted with the community. We really did consult with those intervener groups. The court let us in and not them. And I feel terrible about that, because I think that the court missed the point. But again, it's one of those, it's a 1-judge decision and we don't know what was going on there. But I do think that intervener counsel have to do more of that consultation. Stop just going there because you want to be at the Supreme Court of Canada. And I'm being very blunt and in saying this. It's after my many years of intervening. I think I can. And think about what is your real value added. Your presence as a person is not the value added. Like, you just got to give that up. It's like, put your ego aside and think about what you are actually adding to the case.
Because it seems like, sorry, Anita, I just wanted on this point, Cheryl, to add, it seems like there are 2 types at least of intervention or interveners. There are those who have an interest and that they're there to speak about those interests, but there are those who are acting like experts or kind of amicus. They're helping the court understand some issues. So they're really there to help the court and to assist. And the question here is, like, shouldn't they be there automatically? Like, why should they even ask for leave? Like, they're the types of interveners, and input that they have should be something that the court automatically wants to have in a case.
That's really interesting. And I did want to actually, I don't know how much people know about intervention in the US Supreme Court of Canada. But it's interesting, you know, they don't call it intervention there. They file amicus briefs. And I had occasion to review a bunch of them. I'm now an emeritus member, but I was the only Canadian board member on an American board of the National Association of Rights Protection, and something else with an A, NARPA. And they participated as amicus in the Supreme Court litigation, and lots of other organizations. They signed on to amicus briefs. And it's absolutely common to just file these amicus briefs. And they are really super complex. They have fantastic reading material. And I don't see how the court is hurt by having that level of expertise sort of fairly routinely contributed by organizations like this one, which is a lived experience organization. So I want to go back a little bit to a few things Cheryl has said. It would be one thing if the court on these cases where you have, 36 interveners said, okay, this is ridiculous. We're not losing 2 days of court time to 36 people, 20 of whom are saying the same thing. Those people are going. Or another, potential irritant, Sarah's not going to like this. I don't know that we necessarily need the local criminal defense association across the country in every case, unless there's a specific local perspective. Because sometimes you run a real risk. Like if it's not sort of coordinated in a way, you've got, for example, smaller criminal defense bar associations arguing with each other about what should be happening in the interpretation of the criminal code. Some of those interpretations will be a lot more sophisticated than others. There's no sort of, criminal defense association in the country who's going to point a finger at their counterpart in another part of the country to say what they're saying is just dumb. So then, there's a lot of dynamics, a lot of moving parts. And I think we all agree people have to be thoughtful about, is there something that must be said, and must that thing be said by you? And must it be said right now in this litigation? So, but it would be one thing, and I think everyone would understand if the court said, you know what, intervention is a victim of its own success. There's bloat, the pylons. We're going to put an end to that. But that's not actually what they're doing, though. They're taking 7 potential interveners in a case where nobody objects to those interveners. All the parties have consented, so the Crown doesn't feel prejudiced. Nobody feels prejudiced. Nobody has raised any concern about the scope of the litigation being expanded. And they're throwing out the lived experience. So they are actually, in some cases, signaling, we only want the professionally filtered legal explanation of that experience. That is not going to read as particularly inclusive and particularly emblematic of the access to justice that the court itself has been very strong advocates for. Like, I am very proud of our Supreme Court of Canada for their commitment to access to justice and for the conversations our Chief Justice has started across the country and internationally about ensuring access to justice. We've got a Chief Justice who's very outspoken about legal aid funding, about the shortages of judges in the courts below, about access to justice. We've got a court that's, endeavoring to be very representative, to be more representative than it had been in the past. It's not consistent with that to determine, wake up one morning and say, we no longer consider it appropriate that context be provided through the lived experience of people who will be directly impacted by our decision. It's not great when you receive a decision denying your client leave and you've been told that it's because you've raised new issues. It's not a great feeling when you really want to call up and say, can you just point me to the new issue that I've raised? Because as God is my witness, if I knew that this was going to look like a new issue, I wouldn't have put it in there. And, and counsel everywhere are confused and upset and weirded out and calling each other to say, what do you think I said that's new? That's not appropriate. So, for example, if you've got an appellant's factum, full of presumptions and myths and stereotypes about a group of people. So you've got, a factum that starts with drug users or addicts and criminals. And you've got, an intervener group who wants to come and say, we're the drug users and we're neither addicts nor criminals necessarily. If the court says, oh, well, that's new information we can't hear. But you're hearing legal arguments premised on stereotypes. And so we're not, it's not a question of we'd like to swear an affidavit and bring you empirical evidence that we've built by surveying the community to prove that as individuals, we're not addicts or criminals. Again, it's references to royal commissions and so on. Is that expanding a record in a way that's prejudicial to the parties? I don't know, but this is what we're down to. Like, maybe this sounds like it's a little bit in the weeds, but these are the problems that we're facing now, because it goes back to what we discussed at the beginning of our session here, is the intervener must bring something new, but not too new, right? And that it's that fine line, which is entirely subjective. So if you're a single judge and you're looking at something, that determination, is this too new? Is it new enough or is it too new? Is an extremely subjective determination at the end of the day. And without very specific sort of express guidance on how you determine what is just new enough, but not too new, you're going to have chaos. And what I think you can relax a little bit about, Cheryl, is I don't think the little people are going to do a lot of outreach to the bigger people, inviting them to come on anymore. I think they'll be quietly, jealously guarding any new intel about an appeal that might go forward and discouraging others from telling anyone else. So, but that's again completely unhelpful.
Yeah, I
To
think
the
that's a
court.
shame. I think that would be terrible.
It would be.
And I really, I've long advocated that we need to coordinate and talk to each other and making sure that we give space for those groups. And if that means not intervening in a case because, you know, we might take up that space. I've always advocated for that. It hasn't always turned out that way. It's not, those have always been my intentions. But I also think that going back to what you were saying about the US Supreme Court and amicus briefs, and sort of a similar thing. I mean, years ago, when I first started at the Asper Center, we're now talking 15 years ago, we did a symposium on interventions. And I had a panel of people someone from the UK, someone from the US, and someone from Canada, just talking about the different approaches. UK, way more restrictive than we are, doesn't let people in, but then when they get in, or groups get in, they get to really fully engage. So they get to make full arguments. They're not reduced to 5 minutes, but it's just rare to get in. The US with these amicus briefs, so anybody can put in a brief. There's no filtering of that, but none of them get to make oral argument. So you just hope that the clerks are going to go through those briefs and weed out the ones that are clearly relevant and helpful, make sure the judges see those. And then we have ours, which is kind of a middle ground, but I think we're moving in some ways toward that. Well, we were when we were having this expansion of interveners, moving towards that American model, because I don't think 5 minutes is particularly helpful. We do 5-minute speeches. You don't get to engage with the judges. I hate making those arguments because the minute you get a question, often judges' questions are a bit rambly and not on point because they're thinking things through. It's not a criticism of them, but then they've taken up your 5 minutes and you don't get to engage with that thought process. So it's kind of a pointless exercise of the 5-minute arguments. I've seen some very effective ones. I'm not sure I've ever done one, but and that's maybe why I hate them so much. But I do think that we
don't listen to Cheryl and I. Both Cheryl and Sarah are incredibly effective in their oral argument, even with those 5 minutes. I think it's worthwhile to pause here to say that I watch a ton of Supreme Court TV. I started before my first appearance there, and I watch oral argument of things that like have nothing to do with me. I'll watch anything. I'll just watch hours and hours of this stuff because I'm so interested in the advocacy that goes into it. And I can tell you that the range of advocacy in the Supreme Court is astonishing. You can have 5 sort of breathtaking moments from counsel where you could hear a pin drop and you can see that every judge is completely fixated on absorbing each syllable out of the mouth of that lawyer. And that's just a beautiful experience as an advocate. And I've seen Sarah have a moment like that, actually, which is really gratifying. So I'll try and take credit for it wherever I can, if I can. But I've also seen train wrecks. And since we're having this session and maybe there are new lawyers watching, sometimes new lawyers get advice like, oh, don't script your argument. You know, don't read. You know what? Script your argument and read in your 5 minutes in the Supreme Court of Canada. When I see young people who think it'll be more effective somehow to have that conversation with the court during those 5 minutes, they, black out, blank out. They have no idea what they're saying. They're trying to make things up as they go along. They have like their 3 bullet points and they think that they'll figure out how to fill in those 5 minutes from that. Terrible idea, always a train wreck, very embarrassing, vicariously humiliated for them. On the other sides are sometimes very senior counsel who are in and out of the Supreme Court of Canada. We're just so used to, being there that sometimes you get the feeling they rolled out of bed that morning and thought, oh, yeah, I got that thing in the court. And show up and speak to something that they haven't really turned their mind to in a concerted way. And that's not any better. So even though it's 5 minutes, if you're going to be in that court, you take it seriously, you script it, you reflect on it, you test drive it with your colleagues and friends and your 12-year-old son, if you have one, because that's apparently the perfect target market to know how it's going to be absorbed. Sorry, I have no idea. Now I'm just rambling, and I'm sorry, I didn't mean to take everyone off course here. But my worry, Cheryl, is that we're headed in this country toward the worst possible mix of the American and the English model, where we're going to cut down on intervention. Very few people will be let in, and they still only have the 5 minutes. And that's
I agree.
One of
And that's why where I was going to with what I was saying is that I really wish, and I think a lot of lawyers have sent this message to the Supreme Court and they're not listening and they don't want to listen. This is the frustration, is that let in all those briefs, but then be more selective about who gets to do oral argument based on what those briefs say, and give us more time to actually engage. That's what I would like to see. And I'm not the only one who has said that. I know many lawyers would feel much more satisfied if that you don't carve out people who have the experience, but you look at the quality of the brief and see, are there questions that I have about these arguments, and then allowing those arguments to come forward in a way that you can clarify and have that dialogue. Because I teach students how to do this kind of work, and I say, well, the best thing about an appeal is particularly at the appeal level, is it is a dialogue with the judge, and you are going back and forth. You want to get those questions. You want to be able to go back and forth, because that's how the learning takes place in terms of your argument. But if you have 5 minutes, none of that's taking place. 10 minutes, at least there was a little bit of back and forth, and 20 minutes, I mean, it sounds like luxury now. But
Amazing.
I remember
Luxury,
the cases
that's a
where I had a
magnified
real
luxury.
impact.
At some point last year, I shared 10 minutes with 2 other interveners.
Oh yes, yes, I recall.
Mathematically, on its own, a bewildering, because then you're trying to divide the remaining people go over, right? So I'm going to like, what's 7 minutes and 39 seconds divided by 2? Yeah, I think part of the problem, or one of the concerns, is, if you think of the American approach, where you're sort of praying that your brief that's gone into the void is going to get picked up, is that particularly if we're talking about equity seeking groups likely to be affected by the law, groups whose voices are not heard or prioritized or amplified, you are already dealing with, in a situation where somebody has to pick your brief up, the dismissal, the assumption, the invisibility of that client in their life. And the challenge, like, one of the difficulties, I think, and I agree that the bar bears some responsibility, and some of the solutions lie with the bar, right? There's a sort of difficult balance for those who are trying in earnest, thoughtfully, their best, between the job is to be useful, the job is to be of service, the job is to assist in a complex situation. But that also means sometimes notifying the court that they don't know what they don't know. They don't know who they need to look to, and that stuff has been missed that is critically important. And it is very difficult / impossible to do that advocacy from the intervention application, right? And the stage in the process, when it comes, a single justice, half the materials are in, no one is deep in that file, right? I feel like some of the frustration that comes out in the decisions is, why this case is not about what they told us it was going to be about, or this case is not about what they said the issues were going to be, that led to the applications being granted, a year and a half ago or whatever. And so now 9 people are reading FACTA, and it's unclear why, and they've spent half the afternoon listening to submissions from everyone and their dog, and they're not sure why. They don't think the case has anything to do with any of that. none of it was helpful, or it's way different than what is at the core of it. And so there is this, resource driven and also to some extent process, order, timing driven problem of what's actually going to be helpful and what's actually going to be on point. But that is in tension with, the first thing I said, which is like the court is in some situations not the best informed about what's going to really matter, right? A sense of this case is clear might seem true, except that the enormous overlooked impact on particular groups is going to be devastating. And so it actually is much more complicated than they'd like it to be, or than it looks.
And that's why, unless the leave application on an intervention is from an obvious busybody with no business and no connection and no expertise, clearly doesn't satisfy that first hurdle of direct and substantial interest in the appeal. Unless it's someone like that, cutting out a potential intervener whose lives depend on what your court's going to decide, like people who are literally going to die if you get this wrong, who have a demonstrated history of being useful to the court, who are thoughtful historically. Cut them loose at the stage based on an affidavit that is intended to tell the court sort of everything you know about the stuff that you'd be bringing to your thinking then later about the issues, right? Because that's another mistake they make when they deny these applicants. They look at, you've sworn this affidavit, and they think, well, you're going to come and tell us all this and give us all this, and it's too much. And it's like, no, we haven't said that. We've been very clear about the sort of focus we'd have, but we're required to show you that we have this expertise and experience.
Here's how we know it.
This is how we know what we know. And then once we have an opportunity and the benefit of all the facta, we're going to use what we know to formulate the obviously legal submissions that are coming. But at that point, for a single judge to say, this is new, it's too much, it would expand things. You don't know, we don't know, no one knows exactly what we could contribute. But people should maybe be given that chance. And there's just one last comment I want to make, and I think we better wrap up because our viewers certainly have limited attention span, and we've probably long gone past it. But in terms of this conversation with the court, that I think ideally in a perfect world you would have a conversation. I don't think I'm going to be able to make the calls I want to make to go like, what's the new issue? What's the problem? What did I do wrong here? So that's not the kind of conversation, but at least, whatever conversation or dialogue in whatever way we have, I don't think should be focused on some of the things that have actually been part of the conversation. So certainly there's been correspondence and advocacy. And we were in court on one of the cases where one of the big firm lawyers said, if their client doesn't win that particular litigation, then the junior lawyers at the big firm will no longer be interested in working on these pro bono files. And for that reason, they should win. And I think it was one of the judges who summed that up with, okay, so you're an up and coming lawyer, one of the sort of, big firms in town then. And so your argument is that for that reason, you should get to do whatever you want, kind of thing. And that didn't carry a lot of favor with the court. But to a degree, there have been some noises around, don't deny leave to interveners because senior counsel, won't be motivated to try again or whatever, but more along the lines even on the sort of Zoom access, how do interveners appear? Is it by Zoom? Is it in person? So we've heard people saying it's very important that some interveners get to go to the Supreme Court of Canada in Ottawa so that they can appear in person, because if that's not one of the perks, then the senior lawyers won't even be interested because they don't really care to come on Zoom. All that stuff I consider incredibly counterproductive in the current climate because of what Cheryl has already raised, which is the ability and the privilege of a party to participate in litigation in our highest court is not meant to be a perk for either junior lawyers or senior lawyers. It's not meant to be about you. It's got nothing to do with you. It has to do with access to justice for communities whose lives will be directly impacted by the outcome of this important litigation. And we should all be talking about access to justice and access to the Supreme Court. I don't think anyone should care whatsoever about the prestige associated with and whose name gets reported where and how and so on. It's not about us. And one of the first things we learn as lawyers is it's never about us, and it should never be about us. It's always about our clients. And once again, Maya, I feel so much lighter for having gotten so much off my chest. So for that alone, well worth the price of admission. Thank you for the opportunity.
Well, thank you, all of you ladies, for this lovely conversation. I'm sure the viewers are going to learn a lot about interventions and like what's involved and about the current trends and issues that are going on. So I really want to thank you. And Cheryl, you're on vacation, so we really appreciate that you were able to take some time off just to join us today. And Anita and Sarah, I mean, you're always welcome to come
I'm
back
always
again.
here.
Yes.
I'll just stay on the Zoom.
I was happy to
Yeah.
be here. It's a really important issue. I know the Asper Center has had a huge impact on interventions, and we want to be always to be certain that we're doing the right thing. And so I'm pleased to be here and share my views on this and to hear feedback.
And it's been an absolute pleasure to appear with Cheryl and to work with Cheryl on any case I've had the opportunity to work with the Asper Center and Cheryl. Their contributions to the jurisprudence as it develops out of the Supreme Court of Canada are second to none, except possible exception of Joe Arvey. Everybody's second to Joe Arvey's personal contribution in that court. But I think you're seeing, there are lots of people that have a lot to say about this, but Maya, I think you've had a really good cross section of different experiences and expertise on behalf of different groups. And it's a conversation I think we should continue.
Yes.
And maybe we'll come back in some time to check in.
For sure. I mean, it's always a pleasure to have you ladies here on this show for these subjects. And we'll see how things will go with the Supreme Court, and we'll have a part 2 maybe, and we'll continue this conversation. Hopefully it will be a more optimistic one than the one we're having today. So thank you so much, ladies.